We hope you like this video, and thank you for subscribing. Click the link in the description below to read the blog post.
The top 3 reasons 100% TDIU is denied. Why are so many 100% TDIU claims denied? To say the least, the initial disability review process is not veteran-friendly. There's only so much money to go around, so claims review agents often look for technicalities and other loopholes to deny claims or at least significantly reduce awards. Things are much different in the appeals process. At an appeal hearing, an attorney can introduce evidence and make legal arguments. Therefore, the veteran or veteran's family member has a strong voice as opposed to a muted one. So, many claims settle on favorable terms before this hearing takes place. It is important to understand why claims review agents deny claims and how an attorney can respond to these denials. No compensation and pension exam. The VA often requires compensation and pension medical exams, or C&P exams, in ratings increase cases, but they may require C&P exams in other contexts as well. If the claimant does not attend this doctor's appointment, the VA might deny the claim altogether. Or the VA may apply the dreaded as-is label, which basically means we will consider this matter when we feel like doing so. Most veterans' disability applicants are punctual and reliable people who have serious medical issues. If the veteran does not make it to the C&P exam, there is almost always a reason why. No notice. Bureaucrats routinely send notices to the wrong address. They may not give the veteran enough advanced warning about the appointment. Also, they may not include sufficient information. An example would be how to get to the doctor's office. They may change the appointment at the last minute. There are basically 2 types of C&P exams. General practice doctors usually do the initial exams, and if necessary, there is a follow-up with a specialist. Sometimes, the wrong kind of doctor performs the C&P exam. Failure to make accommodations. Many disabled veterans have a hard time getting from point A to point B. If the appointment occurs on a bad day instead of a good day, the difficult day may become impossible. As mentioned, at an appeal hearing, an attorney can make arguments in this area. No disability service link. Often, the VA orders C&P exams if the service link is disputed. These disputes are especially common if the claimant is a Gulf War or War on Terror veteran suffering from breathing problems. Legally, there must be a reasonable direct connection between the service and injury. If the veteran was in Iraq or Afghanistan and is experiencing breathing problems, the VA often says that the desert climate is to blame. The VA often rejects claims outright on this basis. At an appeal hearing, an attorney can present an independent doctor's assessment, which concludes that there is a connection between the illness and service. Typically, that is enough to reinstate the claim. Insufficient in-service evidence. Claimants suffering from post-traumatic stress disorder must point to a service-related illness, injury, or other event which caused the PTSD. Many times, the medical records are vague on this point. That vagueness is enough to justify a claim denial. Or, in most cases, The VA simply reduces the offer based on the weak evidence and hopes that the claimant will accept the lowball proposal. At an appeal hearing, an attorney can introduce additional records, such as service records, which often identify a triggering event. In the alternative, buddy statements are usually enough. Team up with hard-hitting attorneys. Most initial denials rely on technicalities, which an attorney can address later in the process. For a free consultation with an experienced veteran disability lawyer, contact Cameron Firm PC at 800-861-7262 or fill out the contact box on our website, www.veteranappeal.com. We'll put the link in the description. We serve veterans nationwide, and there is not a fee until you win.